This video explains the MLS or cooperation rules for the Chilliwack, Fraser Valley, and Greater Vancouver boards, revised March 17, 2025. The rules are enforceable through the Fraser board's bylaws. Breaches can lead to discipline, fines, or suspension of MLS privileges. You are also responsible for errors or misconduct by your unlicensed assistants and administrators. 1. Your MLSR information must be accurate. As the listing realtor, you are responsible for ensuring that every MLSR field is complete and factually accurate. The commission offered to the cooperating brokerage is correct. The source of property measurements is stated in Realtor ESR. Remarks. You check the listing again after it is published. You do not simply copy information from another realtor's previous listing. Think of the MLSR entry as a formal professional representation, not casual marketing copy. 2. Know the major listing deadlines, requirements and deadlines. Submit or enter a new MLSR listing within 3 calendar days, excluding statutory holidays. Post title search or ownership document. Within 24 hours of activation, post at least one property photo. Within 24 hours of activation, post registered strata plan. Within 24 hours of activation, correct an MLSR rule. Violation after notice. Within 1 day, enter a seller-authorized listing change. Within 2 calendar days, report an unconditional sale. Within 5 calendar days, provide documents requested by the board. Usually within 1 business day, MLS listing contracts must generally run for at least 60 days and have definite commencement and expiry dates. Extensions must be signed before expiry. 3. Use the standard forms properly. The board's standard MLSER listing contract must be complete in every detail and generally cannot be modified. Make sure all registered owners sign. Special ownership situations require evidence of signing authority, including corporate owners, powers of attorney, estates and probate representatives, receivers or trustees, court-ordered sales. Do not assume that the person instructing you has legal authority to list the property. Verify it. 4. Remarks fields have different audiences, public and internet remarks, seen by consumers. Do not include names, phone numbers, email addresses, or web addresses as contact information. Realtor are remarks intended for members and may include permitted contact or showing information. Commission must appear only in the designated commission field, not in remarks. Information should not be removed from an existing listing merely to prevent it from remaining in the historical MLSER record. 5. Photos have strict rules. Listing photos must relate to the real property being sold. Not permitted, for sale, or sold signs visible in the photos. Promotional information about the realtor. Text, comments, or added marketing information on the image. Images of children. Unapproved watermarks. Photos other than the front exterior photo generally cannot be reused in a future listing without the originating brokerage's consent. 6. Business and commercial listings receive some special treatment. For your commercial practice, these provisions are particularly important. A business listing must identify a current place of business. The business name and address can be suppressed by the MLSR department upon the listing brokerage's written request. A title search is generally required for property listings, but not for a business without land listing. The CREA Realtor Cooperation Policy's public marketing requirement exempts commercial properties, business properties, agricultural properties, new multi-unit developments, and rental listings. Even where that CREA policy exemption applies, the ordinary board listing submission requirements may still apply. The rules also treat references to sellers, buyers, and sales as including landlords, tenants, and leases where appropriate. 7. Showing restrictions must be documented. A new active listing generally cannot be unavailable for showings for more than 5 calendar days. A short no-show period must have defined beginning and ending dates. Be authorized by the seller in writing. Be disclosed in Realtor. My team. Remarks. Be respected by the listing brokerage. Longer periods may require the listing to be placed on hold or canceled. The buyer must be accompanied and supervised by a licensee throughout a showing. Do not deal directly with the seller unless the published listing instructions permit it. 8. Offers must be presented promptly and confidentially. Unless the seller signs a proper direction regarding presentation of offers, offers must be presented without delay. Offers are presented through the listing brokerage. The cooperating realtor generally has the right to attend the presentation of their offer. The terms of offers and counteroffers must remain confidential unless the seller gives written instructions otherwise. Delayed offers and preemptive offers. When a listing says that offers will not be presented until a stated date, the direction must be in writing and posted to MLS. The date and time must appear in the appropriate remarks. If the seller later wants to consider an early offer, the seller must sign a revised direction. The listing must be updated before presentation. Other interested cooperating brokerages must be notified and given a fair opportunity to submit offers. This is an easy area for a new realtor to make a serious procedural mistake. 9. Multiple offer procedures are formal. When there is more than one written offer, inform the competing brokerages that multiple offers exist, unless the seller directs otherwise in writing. Do not disclose the terms of the competing offers. Present offers in the order received. Continue presenting offers until one is actually accepted. Complete the disclosure of multiple offers presented form. Have the seller sign it. When an offer is accepted or all offers are rejected, provide it to the participating brokerages and unrepresented buyers, no later than 1 calendar day afterward. The listing brokerage must retain copies of presented offers for at least 1 year. 10. Sales must be reported. Even when inconvenient, the listing brokerage must report an unconditional MLS sale within 5 calendar days, with the sales report form and a legible copy of the contract, addenda, and amendments. Important details: sale prices are reported exclusive of taxes. A listing cannot be canceled merely to avoid reporting the sale. Changes to completion dates must be reported immediately. A collapsed transaction must also be reported immediately. You must check the published sale information for accuracy. 11. Do not solicit clients under active exclusive agreements. You generally cannot solicit a seller whose property is actively listed with another brokerage, a buyer or tenant who has an exclusive representation agreement with another brokerage. Before entering a representation agreement, make reasonable efforts to determine whether the client is already subject to an exclusive agreement. General advertising is permitted, but it must not be targeted specifically at people identified through active MLS listings, signs, or MLS data, and should clearly state that it is not intended to induce a breach of an existing agency agreement. 12. Advertising another realtor's listing requires permission. You normally need the listing brokerage's prior approval before advertising its active listing, subject to authorized MLS reciprocity arrangements. After a sale is published on MLS, the cooperating brokerage may advertise its involvement, but the listing brokerage must be identified. Only permitted MLS data may be used. The sale price cannot be advertised before it becomes publicly available through a government registry unless both buyer and seller provide written approval. 13. Commission rules matter. The listing contract must state the total commission payable by the seller, the portion offered to a cooperating brokerage. An offer of zero compensation to a cooperating brokerage is not acceptable under these MLS rules. A cooperating brokerage cannot use a buyer's offer to change the offered compensation unless the buyer separately authorizes it in writing and there has been prior consultation with the listing brokerage. 14. Never accept cash or cryptocurrency. Members must not accept cash deposits in bills or coins for real estate trading transactions, other than the stated rental or leasing exception. Cryptocurrency as payment in any real estate transaction. Checks, electronic transfers, and money orders are not treated as cash for this rule. You must also follow applicable FinTrack requirements. 15. Lockbox access is personal and confidential. Obtain the seller's specific written authorization before installing a lockbox. Never share your mobile lockbox access. Keep PINs and passwords confidential. Follow the listing's access instructions exactly. Verify that the property is secure when leaving. Return keys immediately. Report suspected unauthorized access to the board immediately. A one-day code should not be given to an unverified person and normally may only be provided to a properly verified licensed member. 16. MLSR data is not yours to distribute freely. Do not share your MLSR password or access code. Give MLSR information to unlicensed persons outside the ordinary course of business. Use BC assessment information to build solicitation or mailing lists. Allow clients, assistants, or third parties to scrape or improperly redistribute MLSR data. You can be held responsible for misuse of MLSR information you provide to someone else. The 5 habits that will keep you out of trouble. Get every important client instruction in writing. Diary every MLSR. Offer and sale reporting deadline. Verify ownership and signing authority before listing. Review the published MLSR entry immediately after it goes live. Ask your managing broker before improvising with forms, offers, advertising, or compensation. The overall theme is simple: accuracy, written authority, equal cooperation, confidentiality, and prompt communication. Those 5 ideas run through almost every rule in the document.